All right, I'm going to talk to you about privacy. One of the things you're going to see very quickly is that while it seems like a very discrete topic, privacy restrictions, privacy controls, it's really wide open because of the sources of the law, where we may find problems. So it is very much wide open. Now, why would you be concerned about privacy? If you are doing any kind of work where you are handling personal information for one of your customers that they may be gathering, you're going to be subject to the privacy laws. Three big issues that we see with privacy laws. Number one, we want to protect private health information. And I will actually talk about that probably throughout, but mainly at the end when I talk about HIPAA. We want to protect financial information. So if you're gathering any of that or holding that or maintaining that, you're going to see lots of restrictions. And finally, we're concerned about identity theft. Now, the sources of the law are both state and federal statutes. And the federal statutes tend to be very specific. We've got statutes that apply to financial institutions, statutes that apply to healthcare entities, things like that. The state laws tend to be more wide open. They're much more broadly drafted. They will not be restricted to certain industries for the most part. Vanita was talking a little bit about the difference between state and federal jurisdiction in the U.S. And yes, it's true you could be sued in either court, either state court or federal court. Typically, you get federal jurisdiction if it's a federal question, which means that a federal law is involved. So if it's one of the federal statutes, you're probably going to be in federal court. The federal courts also have pendant jurisdiction. So if we have a federal law that's been violated and the same conduct violates allegedly a state law, then the case will be brought in federal court and the federal court will hear both the state and federal claims. And then there are times when we have this diversity jurisdiction. And by diversity, we mean diversity of citizenship, meaning that the parties to the lawsuit are not both citizens, both sides are not citizens of the same state, that there is diversity of jurisdiction between the parties and at least $75,000 in controversy, then the case can be removed to federal court. All of that is somewhat important in the sense that if you're a defendant, you generally want to be in federal court. And the reason for that is the plaintiff will probably bring the case in state court. In most states in the United States, the state court judges are popularly elected. So there's a chance that they might be closer to the plaintiffs, if you will. The federal judges, although they're local judges, are appointed by the president for life. They don't ever have to run for election. They don't have to, more importantly, raise money for elections. So they tend to be a little more impartial, shall we say. So if you're a defendant, you will probably want to find a way to remove the case to federal court. All right, there is also common law claims. By that I mean judge-made law. This is just, evolved in the courts. The two big ones are invasion of privacy and negligence. And I'll spend most of the time when we get to that talking about negligence. All right, just a few federal laws to kind of illustrate. Graham-Leach-Bliley Act applies to financial institutions and insurance companies, also applies to sort of related companies like real estate appraisers who may be assisting in arranging mortgages. They'll be subject to this. And what we're trying to do here is protect customers' financial information. You have to institute reasonable controls. If there's been a breach, you've got to conduct an investigation. If there has been a breach, you may have to take steps to mitigate. You may, any damage that may arise. And you may also have to notify customers. It's cumbersome. It is not a situation you want to be in. By the way, just as an aside here, you've got to be concerned about all of these things because, again, if you're, as the other speakers have said, if your customer is subject to any of these restrictions and any of these laws, they're going to stick an indemnification clause in your contract and hold you responsible for any problems that you cause. So just be aware. One thing you will see as we go through this, and when I get to the end we can kind of wrap up with it, is the fact that one set of protocols, one set of procedures will probably protect you or give you some comfort with respect to all of these various laws. But let's continue on. Okay, the next federal law I want to talk about are something called the red flag rules. These were, we really had a hard time implementing these. The law was first passed, I think, in it was supposed to take effect in 2009. It took a while for everyone to get in on board. They kept delaying it. It is actually a law that is enforced by several federal agencies, the big one being the Federal Trade Commission, and then also the Controller of the Currency for financial institutions. What the red flag rules are concerned about is identity theft. Okay, so you have to, skip that slide. You have to put in place protocols, procedures to protect against identity theft. And they call it the red flag rules because they've identified, or you're supposed to identify through your procedures, certain events that trigger a red flag, that cause you to be concerned that somebody might be engaged in identity theft. So it applies to you if you've extended credit to someone. Or, in your case, perhaps your customer has extended credit to someone. And then something happens and you suspect that there might be an identity theft problem. Something very simple. Credit's been extended to a customer. We send a bill to the customer and it comes back saying the customer's not at that address. Oh, okay. Well, who's at that address? Or who gave you that credit card? Or who gave you that credit information? You've now got an obligation to follow up. There may be some identity theft going on. Okay, so that's what we're looking at. At its heart, it's not a very complex concept. It's very mundane. If you got reason to suspect somebody's committed identity theft or there's a problem here, you've got to follow up. You've got to figure out what you're going to do. You've got to have that built into the procedures. It may be something as simple as, okay, it came back. You contact the customer. Customer says, oh, I moved. I didn't give you my new address. Here it is. Once you've satisfied yourself that it is the customer, that this is legitimate, then you can move on. One important thing about the program is you want to periodically review it and update. Now, not everyone is maybe required to do this, but this is something you want to do just to protect yourself. Second thing that is very important to note there is that under the federal law, the program has to be approved by the board of directors, at least initially. And then it's very important that you train the staff. And that's a theme throughout all of these laws, even if you're trying to protect against the common law claims. Train your staff. It does no good to have a procedure if they don't know what the procedure is. And a lot of times, I got to tell you in our experience, a lot of times the problem is caused by the staff just not paying attention. So constantly training the staff. It's not that the staff forgets, but it's like you can remind them periodically that we've got to follow these laws, we've got these procedures. Just be aware of them. Okay, state laws. Now, we were talking earlier about how the United States really isn't united. Well, here you are. 46 states, plus the District of Columbia, Puerto Rico, and the U.S. Virgin Islands, and it was 46 at last count, who knows, have data breach statutes. But it's not a uniform data breach statute. It varies from state to state. Now, here is the really, really bad news. In any given situation, it is the law of the state where the consumer or customer resides that's going to apply to the situation. So what that means is, if you got customers all over the United States, you're subject to all these state laws. And you may, in one data breach, be dealing with, say, the laws in 10 different states. Now, that can get a little ugly. So, generally, not only aren't they uniform, but they're broader in scope than the federal statutes, and they may apply to more than just computerized records. So California, it's personal information maintained in a computer database. If you skip down there, you can see Nebraska and Iowa, they include information that may not be computerized, things like fingerprints. New York has some tighter definitions, but at the same time, their definition of what constitutes a breach is sort of open-ended. They list some factors that may be considered breach in determining whether there's a breach, but there's not one tight definition of what a breach is. Massachusetts has recently enacted a law, recently I mean in the last several years, that many people see as the template, as the model for what may be coming. And you can see who it applies to. Anyone who includes anyone, I just arrived yesterday, so I'm a little tired. Anyone who owns the information, okay? That means you receive it, you store it, you maintain it, you process it, or otherwise have access to this personal information. It will apply to an IT company that is a subcontractor for, say, a financial institution, a healthcare entity, whoever. You have a duty to protect. Yes, sir.
A question here. So when I submit my personal information to a company, is the transmission of ownership also given?
No, you're not giving up ownership of the information. And what we're talking about here for the data breach purpose is that company then is considered an owner of this computerized record that they are maintaining. And therefore, they've got to treat that according to the law. They have to protect the information. You are not giving away ownership of the information. And that's a very good question, because it could be misleading. But no, what we're saying really, we use the term own, but what we're really saying here is who's subject to the law.
Who's possessing?
Yes, who's possessing. And if you have this information in your system, you're subject to the Massachusetts law. Whether you're just holding it for your customer or yourself, whether you're maintaining it, whether you're transmitting it, whatever. Okay? Okay, you have a duty to protect. You've got to put protection in place. You've got to put security controls in place. And again, it is the same thing that I will keep saying throughout. You've got to train your staff. You've got to periodically revisit your policies and procedures. Are they dealing with the most current threats? Under the Massachusetts statute, personally identifiable information has to be encrypted when it's being transmitted electronically. Not all, well, Massachusetts right now is the only state that specifically requires that. But what happens when we get to the negligence standard, the common law is kind of an evolving concept. It's judge-made law. It's case law. But they will look to these various statutes as to what becomes the standard. So under a negligence theory, if you don't take proper care of the information, then you're negligent. Well, what's proper care? Well, Massachusetts has already said proper care is encrypting it when you transmit it. So it becomes part of a negligence standard, if you will. All right. Just some pointers for a minimum compliance program to protect you under the various statutes. And I would say this just goes across the board, even to the negligence standard that we may talk about here in a second. First of all, you ought to have designated people only having access to the system, accessing the information. I would also suggest that you appoint a security officer or an information officer who will be in charge of protecting the information, making sure everything is being properly handled only by the people who should handle it. The second thing is this idea of assessing the risk. And that's something that we'll see, it's kind of a repeated thing. You know, there's a tendency, if you will, for people to use a one-size-fits-all privacy program or data protection program. You know, it's some other companies used it. Maybe your chief information officer or security officer brought it over from their previous employer. Well, okay, that's well and good as a starting point, but you have to assess what are the risks that your company faces with respect to this information, and what do you need to do to protect against those risks. And we'll see, you know, I will tell you under HIPAA, which we'll cover here in a few minutes, one of the biggest areas, one of the biggest failures by companies is the failure to assess the risk and design the data protection program to address those specific risks. The other thing is, in addition to training employees, you've got to discipline them when they violate the procedures. It does no good to have them either not know what the procedures are or not do something about it if in fact they violated them. You need to immediately cut off access to the information when an employee's employment is terminated, whether voluntarily or involuntarily. You know, you can't wait a week, if you will. You've got to oversee all the service providers and subcontractors. If you've got somebody coming in performing a maintenance function on your system, make sure that they're going to recognize that they can't freely access and use the information. You want to monitor who's having access, what's happening with the information. All right. Again, some minimum standards for the system itself. I won't drag you through all of those, but you can see, again, this is pretty much common sense kind of things. But you need to look at these things, see which ones fit for you. Okay, the negligence theory. All right, negligence is the failure to take due care. And obviously, if we have a data breach, the plaintiff is going to claim you were negligent. You didn't take care of the information. That has been a regular cause of action. It has not, until recently, been very successful. And that's because one of the other elements of a negligence claim is you have to show that because someone didn't take due care of this information, you were harmed. Okay, a lot of times there's a data breach, but nobody knows what happened to the data. There's no evidence that anyone's misused it. There's no evidence that somebody's credit has been hurt or somebody's identity's been stolen. So without that, do we have any harm? And so courts were routinely dismissing the negligence cases because it was difficult to show that there was damage and the damage was speculative. This may be changing. In fact, I'm pretty sure it is changing. And so one of the things you've got to keep in mind is that it can be very fact-intensive. The Walgreens case that I have up here, they were hit with a $1.4 million verdict because they had a pharmacist employee who, her husband had had an affair with another woman prior to them getting married. And the other woman had become pregnant. And the husband, former boyfriend of the other woman, had suspected that she had decided to go off birth control. He felt like he had been trapped. Turns out that the ex-girlfriend was a patient at the pharmacy where the now wife was a pharmacist. So the wife checked the prescription records, and lo and behold, the woman wasn't having any birth control pills dispensed. And so she told her husband confronted the ex-girlfriend. The ex-girlfriend sued the pharmacy, Walgreens, and recovered a $1.4 million judgment, which was upheld by the Court of Appeals. Now, very fact-intensive, the intentional conduct there was probably a big factor. This just wasn't somebody made a mistake and sent the information to the wrong place. This was clearly, offensive conduct. So that really probably helped drive this decision. But again, it's changing. Some courts have latched on to this idea of consumer protection laws as a way to keep the case in court. Some plaintiffs have amended their complaint to say not only was the defendant negligent, but the defendant violated the consumer protection laws. Because when the plaintiff signed up for whatever it was they signed up for, and in this case it was the Sony PlayStation, when they signed up, there was all kinds of language in there that Sony was going to protect their information. Sometimes you even pay extra to get enhanced protection. And now there's been a breach. Well, Sony misrepresented that they would protect the information. They lied to the consumer in order to induce the consumer to subscribe. Okay, that's a violation of the consumer protection laws. At least in this case, it was the consumer protection laws in Florida and Michigan. And almost all consumer protection laws don't require showing actual damage. There are statutory damages.
So this was a class action suit?
They started off as a class action suit. What happens is it gets narrowed because at the end of the day, only the consumers in Florida and Michigan are left in the class. But still a problem for Sony. And by the way, any of these things, it's just not talk about bad news for branding. Saying that you can't protect the data is bad news. All right, let's talk about HIPAA. HIPAA is the Health Insurance Portability and Affordability Act, and it includes protection of personal health information. It's a federal statute. It does not include a private cause of action. It is enforced by an agency called the Office of Civil Rights at Health and Human Services, and it is also enforced by the state's Attorney General. However, much of HIPAA is starting to bleed over into the negligence standard. So, even though there's no private cause of action for violating this specific federal statute, violating the federal statute could give rise to a negligence claim. In fact, that was one of the things that was discussed in the Walgreens case. Now, who does HIPAA apply to? Well, HIPAA applies to covered entities. Covered entities are essentially healthcare providers. Doctors' offices, hospitals, pharmacies, clinics. Not anybody here, I don't think. But you may well be business associates. And I don't know why that S got left there, but it looks kind of neat. At any rate, business associates are subcontractors to covered entities. So if you're providing support services to a healthcare provider, you're going to be subject to HIPAA. So here are the healthcare covered entities: a health plan, a healthcare clearinghouse, and a healthcare provider who transmits information electronically. The protected health information is any individually identifiable health information. Now, somebody might say, well, we're just a data aggregation service. We're providing a service to this big hospital to kind of sort out, what kind of cases they have, what kind of results they're getting. And so we're just we're not using the people's names. We're just kind of sorting the information. We're using, anonymous identifiers. I can tell you that the HIPAA rules have a long list of what is required if you're going to treat the information as de-identified. You can't have name, you can't have social security number, you can't have any other identifying number, you can't use the zip code unless you have at least 2,000 pieces of information in the database. It just goes on from there. There can't be anything in there that would link back to an individual. So it takes a lot to de-identify the information. All right, business associate. Look at how this language kind of comes through everywhere here. Very similar to the Massachusetts statute. Anyone who creates, receives, maintains, or transmits protected health information on behalf of a covered entity. So if you're helping a hospital process claims, if you're a data aggregation service, these are the kinds of people who would be business associates. Well, here are some examples. Okay, statute specifically provides who is not a business associate. The healthcare provider themselves is not a business associate. Healthcare providers who are jointly treating a patient are not business associates. So the doctor is not a business associate of the hospital is not a business associate of the pharmacy. Why? Because they're all subject to the law as covered entities. So they're not business associates. One thing I will tell you is law firms are business associates if they are receiving health information in the course of representing healthcare providers. Our law firm has HIPAA policies in place. We have been a business associate. In the course of my practice, I've represented doctors who are caught up in investigations, including criminal investigations for Medicaid and Medicare fraud. It requires that we look at individual patient files, review those claims, see if they were proper. In order for me to look at that patient information that is being produced for the government, we have to sign a business associate agreement. We have to protect that information just like the covered entity. That means any IT company handling protected health information is probably going to be a business associate. Okay, who's not a business associate? Very limited types of entities, employees. If you've got a cleaning company, that was one that came up early on and was sorted out in the rules. Obviously, if the janitor's coming in every night cleaning up the office, the janitor could access, I suppose, health records, but they're not subject to HIPAA. They're not a business associate. We also have, in addition to what we call the privacy rules, there are security rules in HIPAA. These establish just very basic, hardcore kind of protections, technical, physical, and administrative safeguards. They're really, you just have to look at them and make sure you comply. Administrative safeguards, again, just having the training, having the protocols, having procedures to deal with emergencies, having procedures to deal with breaches, physical safeguards, keeping the information locked up, giving access only to people who need to access the information. Technical safeguards, again, transmission security is a big one here. I always tell healthcare providers that if you're going to send patient information electronically, it needs to be encrypted. Now, there is a procedure by which the patient can say, you don't need to bother to encrypt it, but you want to make sure that you've got that well documented. You may hear of something called the Omnibus Rule. The Omnibus Rule took effect in September of 2013. This is essentially a revision of the HIPAA rules that made a few changes. And one of the big changes that it made from your point of view is business associates are now directly answerable to the federal government. It used to be that business associates only owed an obligation to whoever the covered entity was that they were doing business with. Now they're subject to the federal law and the federal government themselves. Just some of the other restrictions contained in the omnibus rule. You can see up there, there's research uses of protected health information. This is where we get into the de-identification. Okay, we can de-identify the information, use it to look at statistics for healthcare research. But again, look very carefully at what's required to de-identify the information. The rules provide model business associate agreements. Essentially, the business associate has to agree to comply with HIPAA. If you violate HIPAA or if there's a data breach, you may have to notify, well, you do have to notify the individuals involved. If it's a large-scale data breach, more than 500 people involved, there's got to be public notification. You also have to notify the federal government that you breached. Then they're probably going to come in and poke around, and then they're going to see that you didn't do a good risk assessment, and you didn't train your employees, and so they're going to fine you maybe several $1 million. And it's happened. I think I'll just go right through this. This is sort of the wrap-up, if you will. For all of this, the one thing missing here is the risk assessment, but once you do the risk assessment, you put policies and procedures in place, you train the employees, you document the employee training, and documentation is key. You hold regular training. It's not enough to train them initially. You got to have regular in-services, maybe once a year. You discipline employees who fail to follow the procedures. If a breach occurs, you take steps to notify the individuals involved and to mitigate. Mitigate may require, if we're going back, say, to the financial data, mitigation may be that you arrange at your expense to pay for some sort of subscription to a service that will monitor the consumer's credit to see if anyone is abusing their credit cards or has stolen their identity. And that's a very good thing to do, because in mitigating the damages, you will minimize your exposure. I've gone a little long, and I'm sorry, but that's Rocky's problem.
One
Yes.
thing is, being a practitioner in information security, I often get asked this question. Companies can do all the right things. They can get the right people engaged as well, right? But breach happens, right?
Breaches happen.
2 days back, the Central U.S. Command got hacked, right? I mean,
Yes.
it was a military institution that got hacked, right?
Yes.
My Twitter account got hacked too.
Yeah. Now, the company can do certain things, right? But in case such a breach happens, what's the countermeasure that they take? I mean, there would be financial damages, there will be reputation damages.
Yeah.
There are certain companies which offer cyber insurance, but there is a very limited cap. So what can be done? I mean, I'm looking at it from the other side, right?
Okay, what can be done? The most you can do is to put yourself in a position to say, we did everything we possibly could. Okay? So we did the assessment, we did the procedures, we were monitoring all along. Where we saw that we had exposure and problems, we've made changes.
Okay. So that's an evidence that you need to present.
Yeah. Now, it's interesting that you mentioned insurance. One of the things, there is data breach insurance, as you said. One of the things that we've sometimes seen in, for example, business associate agreements, is the covered entity requires that the business associate have data breach insurance. We have typically, if we're representing the business associate, taken the position that we're striking that clause. Whether we have, as a business associate, the data breach insurance or not is a business decision for the business associate to make. All the covered entity should be really asking for is that the business associate indemnify the covered entity. Now, sometimes we're successful, sometimes we're not.
some of the companies, apart from following the HIPAA standards, they are also going for the SOX compliance. So, any similarity between this? Because I think HIPAA is also part of the SOX compliance, right?
Yeah, there is a great deal of similarity in the sense, going back to my point, if you're handling different kinds of information, or you're guarding against, exposure under all these various laws, I think really the same common sense sort of protocols apply across the board. And if you go with the most restricted, and HIPAA would probably be one of the most restrictive, you start putting those sorts of protections in place, you're doing a lot of probably all that you can do. But again, I can't emphasize enough, you've got to stay on top of it. It's not something that you say, okay, we got HIPAA policy, and believe me, I know, because I know how my clients are. You give them the policies and procedures, you work with them to develop them, and they say, yep, there's the policies and procedures, see that binder up there on the shelf, there it is. Has anyone looked at it in the last 9 months? No. Have the employees been trained? Maybe. Has anyone reminded the employees? Because as you say, it happens. And when it happens, it's some stupid mistake by an employee who may well be making no more than minimum wage. And how do you guard against that? You just keep trying to drive it home. But it happens. People send the information, you send out a patient record to the wrong patient. Well, that's no good. But it happens.
Good evening. I am aware of the time and I am going to respect time. So what we'll discuss in this part of the discussion basically is sort of a reverse situation where US companies or any other non-Indian companies use India as a base for outsourcing or for processing. And we look at the Indian data protection law that you need to be aware about in that situation. And the discussion will be in two parts. First, we'll look at the applicable law, and then we'll discuss some typical scenarios and that we've seen clients face when they use India as a processing hub, and we'll see how the Indian law applies in those scenarios. Right. So first of all, what really is the Indian law relating to data protection? India doesn't have a specific privacy law or a specific data protection law. Privacy is protected as a constitutional remedy under Article 21, but that's mostly available against state action. For data protection also, we don't have a specific legislation for data protection. What we have is the 2011 rules, which were introduced under the Information Technology Act of 2000. And the Information Technology Act is basically the overarching legislation that governs e-commerce and cybersecurity. And they decided to plug in the data protection legislation as a rule to the IT Act. It's a very small rule, it's about 4 or 5 pages, but it keeps us busy. The data protection rule in India applies to a very limited set of information, which you can see on the slide up there. Interestingly, it doesn't cover some sorts of information which are typically covered in other data protection legislation, such as ethnicity, racial background, etc. And also it applies to information in the electronic form. So it doesn't apply to information which is in physical form because it's under the IT Act. When does the data protection law apply in India? The law generally applies when there is a nexus to India as a territory. So if the activity of collection takes place in India, or if any processing activity is taking place in India, or if storage is taking place in India, or if India is used to transfer data into India or out of India, that's when the Indian data protection law applies. So in the outsourcing situation, collection may not take place in India, but you definitely have storage and processing happening, and that's when the law applies. There are various compliances which Indian law prescribes for entities collecting and processing data in India. And what we'll do is we'll quickly go through some of the important compliances, and we'll see and we'll see how the compliances either apply or do not apply to specific processing activities. The first compliance is consent. Indian law says that consent needs to be obtained from the data subject at the point when data is being collected. So in a situation where we have a US company that's collecting information in the US and then sending that information to India to a BPOC for processing, in that case, the activity of collection is happening outside of India. So first, the IT Act would not really apply to the activity of collection. Secondly, the US company is anyways not subject to Indian law, to the IT Act. Thirdly, after the data protection rules were introduced, the government issued a clarification a few months later, which basically said that for entities which are processing entities, which are doing services of collection or processing in India for other entities as a service provider, they would be exempt from some compliances. So specifically, they would be exempt from the compliance of taking consent. So the Indian entity, when it's only doing processing, does not need to bother about consent. Consent may be relevant for the US entity when it's collecting data from a US law's perspective, but that's not really relevant for the Indian processor. The second compliance is privacy policy. Privacy policy is mandatory for both collectors and processors, and it needs to be available in electronic form on the website of any company that's dealing with sensitive information in India. And it basically needs to have a clear statement of how the company is dealing with sensitive information, what sort of information it's collecting, how it's processing, how it's protecting that information. The third important compliance is transfer restrictions. So Indian law basically says that when any entity is collecting sensitive information and transfers that information to any third party within India or outside of India, there are a few things that it needs to do. A, it needs to obtain consent of the data subject, or it needs to ensure that there is some sort of documentation in place which necessitates the transfer of the data. And two, it needs to ensure that the transferee complies with at least the same level of data protection which the transferor complies to under Indian law. Now, when we look at transfer restrictions in the scenario of data processing in India, what would usually happen is that the data will be collected outside of India and brought into India for processing. Now, when it's collected outside of India by a non-Indian entity, these transfer restrictions do not apply for the leg of transfer from the US into India. However, if the Indian entity is going to further sort of transfer for any reason, then it could apply. The fourth important compliance are the reasonable security measures which any entity dealing with data in India needs to comply with. And this is mandatory for both collectors as well as processors. So there's no exemption to not have security measures in place simply because you're a processing unit. And the way they defined security measures is, the law says that security measures may be contractually agreed, or you may implement security measures which the government has recognized. Today, the government has only recognized this particular ISO standard as one of the recognized methods. So unless a company is ISO certified, essentially it's the internal policies of the company, essentially it's the contracts which a company enters into which will determine the company's security policies. And it's really important for anybody dealing with data, whether as a collector, as a processor, as a storage unit, etc., to actually have a good documented policy regarding how you're protecting information. And this need not always be technical solutions. You know, we've seen a lot of policies which are administrative in nature, which are managerial in nature. Basically, for example, you could have a policy that says that, you know, employees who are dealing with sensitive information of customers, of vendors, etc., need to update their passwords every 2 days. It could have a policy that says that if you take printouts of electronic information, how do you need to deal with those printouts? Do you need to shred them? Do you need to lock them up? You know, things like that. So it's what's important is that you need to have a policy in place, and more importantly, you implement the policy. You know, Ralph spoke very eloquently about the need for training and the need for constant training, and you know, we can't emphasize that enough. It's important to educate the stakeholders in the company about the security policies. Now, we'll quickly discuss a few scenarios where where India is being used as a data processing hub, and we'll see how the Indian law really applies. The first scenario is we have a bank in the US which collects information from its customers anywhere in the world. This bank has a services agreement with a BPO in India, under which it's transferring data to India for processing. Now, and this we're looking at from a purely Indian law perspective. There may be local laws in the US or elsewhere which need to be complied with in any case. So under Indian law, would consent be required? Again, because it's a processing unit, it's anyways exempt as per the clarification which the government had issued. So for the transfer of data from US into India, Indian law would not require consent. Would anyone need to have a privacy policy in place? Yes, the Indian processor would need to have a privacy policy in place. Would any transfer restrictions need to be complied with? Since the transfer is happening, since collection is happening outside of India and it's getting transferred into India by a US entity, there is no transfer restriction which the US entity would need to comply with under Indian law. If the Indian entity is further going to do any transfer, then it would apply. Security measures, yes, it's the Indian entity that needs to implement and maintain a proper security policy. Now, just a derivative of this scenario, if this Indian BPO is not just a processing unit, but is actually undertaking collection as well. So under its services agreement, if it also is allowed to sort of call up customers or email customers and take information from them, then in that case, would consent apply? Now, here because the BPO is basically acting as a service provider, even though the collection is happening by an entity in India, the BPO would be exempt from taking consent because of the clarification that was issued. So any entity that's providing a service of collection or of storage or of processing need not comply with certain compliances under the law, and obtaining consent is one of them. Moving on to another scenario. Now this is something that we've seen very often with organizations that have regional offices all over the world. Take a scenario where we have an organization with an office in the US, an office in Europe, and an office in India. Now, each of these regional offices is collecting employee data at a local level. And they may transfer all of that employee data to the affiliate in India for any reason. You know, we've seen because they want to consolidate records, because they want to consolidate some payroll function or any other function. So they're transferring all of the locally collected data into India for processing. In this situation, let's see what are the compliances that are required in India. Firstly, consent. Under Indian law, when the Indian entity is collecting the data from its employees in India, it would need to take consent because it's an Indian entity collecting in India. But when it's receiving information of employees outside of India, and this information is being sent by a US company and a European company, then they do not require consent from the data subjects in those jurisdictions. Privacy policy, yes, the Indian entity would need a privacy policy even though it's just a processor. Transfer restrictions, again, like we discussed in the first scenario, because the transfer is happening from US into India or from Europe into India, Indian law would not require consent for that transfer. But if the Indian company is going to further transfer, then yes, it would require consent. It would require the Indian company to ensure that the transferee has at least the minimum level of data security. Security measures again need to be implemented by the Indian company in India. Again, the third scenario is a slight variation where the Indian company is doing the actual job of collecting the information. So say there is a portal that is maintained by the Indian company where employees from all over the world can enter their data. Or they're doing it through any other means, you know, through emails or through phone calls. But basically it's the job of the Indian entity to do the collection. And they're also processing all of that data in India. So in that case, even though it's collecting data from all over the world, the collection is happening in India. So they would require consent under Indian law. They would require the privacy policy to be in place. They would require to adhere to transfer restrictions, and they would also require the security measures to be in place. The last scenario we're dealing with is, say there is a company in the US which is basically a hotel, and it has a sort of a group hotel in India. And the website of that hotel is maintained by the US company. So when people try to book rooms or do any reservations on the website, the data is essentially being controlled by the US entity. Now, they send this data over to India under a services agreement for processing, not for anything else, but for processing. Now, in this case, the situation would be similar. Data is being collected outside of India, being sent into India for processing. So consent would not be required when you're transferring the data. Privacy policy would be required to be maintained by the hotel in India, and the transfer restrictions would not apply because again, it's coming from outside of India into India. Security measures would be needed to be implemented by the Indian company. Now, just take a small derivative of this. If the US entity is if there is some sort of a contract between the US entity and the Indian entity, under which the US entity is acting as an agent of the Indian entity in doing the collection. Now, in that case, even though the website is maintained by the US entity, it is acting in its capacity as an agent when it's collecting the information. So does it need to obtain consent under Indian law? Well, the law is not clear in this respect. However, because there is an agency relationship in place, it's very likely that consent requirements would need to be maintained because you have an agency relationship in place, and the US entity is then acting as the Indian entity when it's collecting the information. This is my last slide. When we're, Ralph spoke a lot about data breaches and the steps you need to take when there is a data breach under US laws. In India, we don't have a regulatory authority till now for data protection or for privacy. And Indian law today does not have breach notification requirements as such. Unless any foreign law has any extraterritorial application on an Indian company, there's no such law that requires breach notification. However, we've seen that in outsourcing situations, when there is a contract, when there is an outsourcing contract in place, foreign companies impose very stringent, very stringent compliances on Indian processors, which require them to sort of monitor any breach, report any breach, and take a lot of action if there is any breach. So most of it is contractual. It's not under any law, but there are a lot of contractual limitations which can be placed. The legal penalty which is really imposed is triggered when there is negligence in maintaining security measures to protect information, and the negligence causes wrongful loss or wrongful gain to any person. Now, in that case, the law says that compensation will be given to the affected person. It's unquantified, so it depends on how much loss has been suffered. But the key point is that there has to be negligence, which would assume that there is some duty of care, which would assume that there has been some tangible loss caused to some person. And there is no provision as such which says that if there is no loss, or if you've not proven negligence, you've just not complied, say you don't have a proper privacy policy in place, are you going to be penalized under the law? There is no specific provision, but the IT Act does have a residuary penalty provision which says that if you've not complied with any provision of the IT Act and there is no specific penalty provided, then there is a small penalty of, I think, 25,000 rupees which is prescribed. So the penalties may not be much, but the compliance standards are high. I think that's all I have. I think we'll open for questions.
Can I?
Yes, please.
What form of consent is required? Can it just be like a blanket consent when, let's say a hotel guest is signing in, they consent to the transmission of the information?
Right, so the consent that, first of all, it needs to be in writing. It can also be electronic links, but it needs to be in writing. And when consent is being taken, basically the data subject needs to know what data is going, to whom it's going, whether it's going to be transferred, whether there's an agency that's collecting on behalf of another agency. So these are the main things that you need to ensure in the consent.
Can the consent be revoked at any point?
Yes. So the law basically says that you can withdraw consent or you can refuse to give consent. And the what happens when you withdraw consent or refuse to give consent is that the person asking for consent can refuse to provide the goods or services for which you need consent. This may not work in all situations. Like in an employment situation, if you don't give consent, there's no goods or services really in place. So it's not clear whether it would be considered a misconduct or whether you can take some disciplinary action against the employee not giving consent. But that's what the law really says now.
Yeah.
Now let's do one thing, if you don't mind. I think there could be a lot of people on the phone, and that it would be more inconvenient for them to wait on the phone. Maybe some of them might have dropped out, but if you can take some questions online, if there are any. If not, then we'll quickly go to. So can we just check if we can take anybody from the phone?
Thank you very much. Participants, we will now begin with the question and answer session. Anyone who wishes to ask a question may press star and 1 on the touchtone telephone. If you wish to remove yourself from the question queue, you may press star and 2. Participants are requested to use only handsets while asking a question. We have the first question from the line of Arvind Pardesi from Reliance Industries. Please go ahead.
Okay, thank you everyone for the sharing of the knowledge. My doubt is that suppose, for example, there is an agreement between two companies, a company ABC from India and company XYZ from USA. Now what has happened? There is a mutual clause regarding the corruption and bribery, wherein the fact is that assume that the Indian company have bribed the US company. Now is there any bad or wrong consequences which I will have to meet up or face under the advance laws? I mean, beside the Indian Penal Code.
Yeah.
Yes.
And this is Vinita Mehra from Kegler Brown. That's a very good question, and actually I should have clarified in my presentation. The Foreign Corrupt Practice Act comes into place when you're bribing government officers. So that's the most important distinction. So if there is corruption happening between two private entities, obviously you won't be under the FCPA, but however, you are violating the code of conduct. And then based upon corruption activities, there could be civil cases and so on. But the FCPA purely applies when there's corruption activities happening with foreign officials. And the definition of foreign officials are basically government officers, be it in the US or be it in India or be it in China. So that's actually the distinction. So I guess you had a very good question, and thank you for giving me an opportunity to clarify that doubt, that it would apply in this context of foreign officials or government officials only.
Yeah, Nishith Desai here.
Nishith here, just to,
Yes,
Yeah.
please.
Okay, beyond FCPA, now the other countries have introduced bribery acts, right, the UK. And my understanding is that even covers private, corruption acts.
Code of conduct, yeah.
Yeah. So you just get to understand that this situation could also arise. And I don't know if US would change law some point in time, but at the moment, at least, it covers only governmental officials. Thank you.
Right. See, Nishith, my question is that, I know that we are doing something unethical and something wrong. But
We are not doing unethical, we are only advising. So, okay, I appreciate, if you don't mind, I'll be delighted to discuss this point offline.
You know that,
Yeah.
and I also know that
Yes.
there is something unethical and something legally wrong act has been committed, and you and I are fully in knowledge. But the issue is that yes, you know that UK Bribery Act has the jurisdiction limit, the FCPA has the jurisdiction limit, but the governing law provisions of the main agreement says the laws of the India. Then in that case, I think yes, it is not provision will apply or that provision apply, right?
These are extraterritorial provisions as well, by the way. It's not just confined. So, you know, this is a little tricky, but maybe if Vinita wants to spend 30 seconds, there are a lot of people who want to ask questions, but and we'll be delighted to discuss in more detail. But Vinita.
So as Nishith Bhai said, your agreement can be governed by laws of India. But however, the clause which you have on compliance with laws, we make sure that in the definition we put in that FCPA. So even if it's laws of India, you have not complied with FCPA, we try to tie that to the indemnification clause. So if your US customer or US service provider or US partner gets affected due to your non-compliance of anti-corruption law, then we try, and if the US company has suffered damages because of that, or they were penalized by the Department of Justice in the US, the tie-up is actually through indemnification. Now the question arises, where will you enforce this clause? Then that gets tied up to your dispute resolution clause. So there are multiple layers that you have to look at. You can't look at FCPA in isolation or compliance with law in isolation. You have to look at it, what will happen when you want to enforce it. What do you have remedies in terms of recovering damages through indemnification or what? And you have to look at the whole agreement as a whole. So you can just not say, oh, I have Indian law governing, so what are you going to do with me about FCPA? That's the same argument that I said early on. Gauri and I face this all the time because the Indian companies like, yeah, who cares about FCPA? I'm in India, Indian law, who's coming after me? But you have to look at the agreement as a whole, that what can be the repercussions of it if you don't comply with the compliance with law. But yeah, we'll be happy to discuss with you all at a later time, but don't look at it in an isolated manner.
Any other person on the phone? So we can relieve them first. Just please bear with us for a couple of minutes.
Sir, there is no participant in the queue as of now.
Okay, so we can go on. Please tell your name and question.
Yeah, I am Sunit here. So I had this question about the rules that you talked of under the IT Act. Sorry. First of all, when you say they are only rules, they don't have the provision of law per se. They are just a statute which has been created under the law. When they don't have any penalty or remedies, it is basically a toothless law. Don't you think so? It is just a feel-good law to ensure that we get the BPO business, and the other countries think that we are compliant when we are not actually being compliant in terms of remedies, at least.
So, the rules do have the force of law because it's enacted as a part of the IT Act. It's enacted under one of the provisions of the IT Act, so they do have the force of law. And it's not just a feel-good factor. It may not be adequate or adequate. That's a separate, argument. But they do have the force of law, and there are penalties which are triggered when there is negligence in implementing the security standards. But like I mentioned, there is no specific penalty for non-compliance, which is not very unusual. Even Ralph had mentioned that most of the action is taken when you've been negligent, and not just because you forgot to do something. So when there's actual negligence, which means there's been a serious lack of processes in the company, that's when the penalties will trigger. But yes, one, they do have the force of law, and second, there are some penalties.
I think just to add to that, one is the civil sort of remedy that Rakhi mentioned. There is another provision under the IT Act which is more of a criminal nature, but that is where it is more of intentional disclosure. When there is intentional disclosure of confidential information or personal information that has been shared with an organization, and such intentional disclosure that is equivalent as you may understand under the criminal law, that intentional disclosure will be considered to be an offense, and then there are criminal sanctions also in that case. But that is in case of very rare situations.
Basically, it's when there's breach of contract.
Yeah, in case of a breach of contract.
I'll probably extend. In Maharashtra itself, there have been cases, divorce cases, where IT Act provisions have been used, wherein exchange of confidential information was done. There are rulings as well. Electronic information was disclosed to somebody, which was material to the case, and there was a financial penalty done. There are rulings now. It's just this law.
Okay, thanks.
Is there any
ended with.
What would you like to list?
Okay, thank you. First of all, Vinita and Ralph, for coming all the way and educating the audience here and on the phone. Thanks to NASSCOM. NASSCOM has always been, supportive of any initiatives that we have been taking. So just one email from us, and they are, all there to support us. And the other, what we are planning with NASSCOM is in fact an annual sort of event calendar, and you will shortly receive, probably once we finalize that, the next one probably being on after the budget on the tax issues affecting the IT industry, because that's something we'll really need to understand, especially with various tax regime changing. Rajesh may be able to add more once we have the budget. So that's the next one on the calendar. And thanks Rajesh, thanks Rakhi for contributing on the India side. Thanks for the wonderful audience. I think your questions have been very relevant, and I was watching that some of you were taking notes. So I hope this event has been helpful for you. And most importantly, we look forward receiving any feedback that you may have. So it will help us to better plan for the next events as well. Okay, thank you. And if you have any further questions, we'll definitely be happy to discuss it while we, informally talk after this particular event. Thank you very much and have a good evening.